This lecture is an introduction to property research. I say introduction because property research can be a very deep and detailed subject. So research can mean many things in the broadest sense of the word. You have scientific research, you have political research and polling. In general, though, what we surveyors mean by research is gathering of information in the preparation for and in the execution of accurate boundary retracement. So property research, to be done properly, it's vital to producing accurate results. The proper gathering and analysis of property research is one area where boundary surveying pulls away from engineering measurements and other geospatial sciences. So this course is the legal aspects of surveying, and this is one of the areas where it becomes a lot more drawn away from your typical math and science and engineering philosophies. And many in the engineering and geospatial world view land surveying as just being precise measurements. You just go out there and find the pin and measure to it. Well, that's only part of good land surveying work. So before we go further, even though this topic is on research, we need to understand why research is important. And that is the difference between precision and accuracy. Precise just means that you have measured very precisely. If you say the line is 423.17 feet, by gosh, it's 423.17 feet within just a little bit. That's very precise. Precise in the old days in geodetic surveying was turning angles with a theodolite that would turn angles to 1 second or 1/10 of a second. Calibrated steel tapes that were daily calibrated to their correct length and certain barometric pressures, temperatures, and there were adjustments made for every 10 degrees of Fahrenheit meant a certain adjustment in the measurements to get them very precise. Accuracy, though, is more important in the boundary survey world. One thing I would point out is measurements point us to the corners. The corners themselves control regardless of the measurements. That is a long-standing doctrine that we will get into later. One thing I like here is, according to the Merriam-Webster dictionary, accuracy is 1, the freedom from mistake or error, 2a, conformity to truth or to a standard or model, or 2b, degree of conformity of a measure to a standard or a true value. You would have thought that the people at Merriam-Webster were land surveyors. And two of the most common sources of surveying errors that create title issues, state board complaints, and lawsuits, and hard feelings and bad business are 1, inadequate property research, and 2, the improper application of measurement analysis. In other words, putting precision above accuracy. This happens way too often. With modern surveying equipment and technology, it's easier than it's ever been to do precise surveying. Being accurate is more important and even easier in the modern era due to better access to property research. There's a book that we'll get into more later by a gentleman named A.C. Mulford. It was published in 1912, and surprisingly, large amounts of that book are still shockingly accurate as it pertains to land surveying now. And he said it is far more important to have faulty measurements on the place where the line truly exists than to have accurate measurement where the line does not exist at all. So in other words, precision is great, but do the research and get the line in the right place. That is more important. That is underlined and in bold. Please remember that. You may see it again. So in the state of Georgia, we have state board rules that have been here for decades, long before my tenure began in 2003 as a state board member. And these are very important writings. Many state board rules are, you might deem them as technical minutia, but this is not technical in nature. This is very direct as to our instructions. This is the very first board rule on property surveys. The preamble, .01, says in order to assure the public that proper and adequate surveys, maps, plats, and writings are executed in connection with property for whatever purpose, technical standards are hereby established. These standards establish the minimum degrees of accuracy, completeness, and/or quality in the several areas of concern in order to be considered acceptable. This rule, though, deserves a lot more attention than it gets. This is after the preamble, this is the very first board rule dealing with property surveys in the state of Georgia. And I'll also say that most states have similar introductions, similar rules, similar guidelines. These are also very similar to what should be undertaken for an ALTA NSPS land title survey. So every parcel of land whose boundaries are surveyed by a land surveyor should be made conformable with the record title boundaries of such land. The land surveyor, prior to making such survey, shall acquire the following prerequisite data: deeds, maps, certificates of title, centerline data, right-of-way data, adjacent descriptions, and other boundary line locations in the vicinity as necessary or available. There's a lot in that. The land surveyor shall compare and analyze all of the data obtained and make the most nearly correct legal determination possible of the position of the boundaries of such parcel. He shall make a field survey traversing and connecting all available monuments appropriate or necessary for the location and coordinate the facts of such survey with the predetermined analysis. Not until then shall the monuments marking the corners or such parcels be set, and such monuments shall be set in accordance with the full and most satisfactory analysis obtainable. It shall be the responsibility of the land surveyor to evaluate conformity with adjacent tracts for overlaps and gores and to report the same on all maps, plats, and reports. That's a mouthful. That's a lot. But if you'll stay within that and abide by that, you will be a good surveyor and you will turn out good work and you will have a very minimal amount of trouble and heartburn. Notice that, I'm going to come back to a little bit of this. You have to get boundary line locations in the vicinity as necessary or available. So if it's necessary to get it right, you have to keep going. We have to, before we get started, go through this data, and then from here up, the first part of this rule is what this module is about, gathering the research. In the next module, we'll go into comparing and analyzing the data. So we're going to take this apart. Reciting it again, I have stressed two parts of this rule, that surveyors should be, our survey should be conformable with the record title boundaries of such land. The recorded descriptions, the vesting descriptions, that is what we need to conform to. That doesn't mean we need to copy it or that our survey needs to look exactly like it, but our survey should be conformable to it. It should be guided by and within the bounds of the record title boundaries of such land. We also have to take into account the adjacent properties title. Notice the rule says that these things are prerequisite data. You know what a prerequisite is. This is something that has to be done first. So let's go through these. Deeds. Obviously, we have to start with our own vesting description and other deeds as well. Maps. This means maps in the sense of plats, as well as tax maps or any other relevant maps, such as land lot or district maps. Certificates of title. Although not always available, having the benefit of any title work is beneficial to the surveyor's analysis. Centerline data and right-of-way data. This is when you're abutting a street, a road, a highway, a power line, a gas line. These things are very relevant, and such data is generally quite available if you look for it. Adjacent descriptions, as you saw in the rule, analysis for the conformity of gores and overlaps and reporting of the same is required. So we have to know what those adjacent descriptions mean. Then other boundary line locations in the vicinity. they may be more available than one would think. Often the solution that has the surveyor stumped can be found in an unrecorded plat that an adjacent owner comes out in the yard and says, "Hey, you want to see my survey?" I've had this happen many times. Sometimes if you're stumped in where a boundary is supposed to be, if you just contact the adjacent owner. Used to, we looked in phone books. Now we generally will mail to the address on the tax bill, or try to find a number for the person if we know who they are, where they work, or something more about them. There are also a lot of tax assessors. People would take plats to the tax assessor to have their acreage adjusted on their tax bill, but the plats never got recorded. Some places have been real Nazis about recording plats, and so recording plats have been not very common. It's been shunned. A lot of attorneys in a lot of areas habitually will shy away from trying to record a survey. But people would take them to the assessor's office to have their acreage adjusted. So some tax assessors kept those. I know of one county where old plats is an available link on their assessor page for a certain, when you pull up a certain parcel, if they have a plat on file, you can access it through a link. Others, you might have to go and look at the actual old paper files that they have stored away. There's also, especially in Metro Atlanta, there is a private repository of records where old plats have been deposited and are available. You can search them and buy them. It's called the Georgia Land Surveying Archives. It's ran by the people that do Georgia Land Surveying Company. So that's available. You can search it for free, but the images you have to pay for. That's how they make their money and recoup their investment. So the proper assemblage of this prerequisite data can be simple, sometimes it can be quite intricate. In many cases, it may have an element of trial and error. You may find that what you thought you needed is not what you needed, and you have to keep digging. While the compilation and analysis of the data is studied in the next module, it bears pointing out that gathering and compiling the data generally go together. Once you earn the skill sets and know what you're doing, as you gather the data, you begin compiling it, even if you compile it in your head. So whether the vesting description has been provided by the client or not, the first step of the research is to go to the tax map. And we'll talk about tax maps a lot, but this primary purpose would be to find what they believe is the vesting deed for your subject property. Many counties in Georgia and in other states use the service that the Schneider Corporation offers called QPublic. Most people are familiar with QPublic. Most counties have a QPublic page where their tax maps and tax records are available. Other counties use a GIS system, usually based on ArcGIS, which is an ESRI product. Some counties actually have both. Cobb County, for example, which we will look at in more depth, has both. So before we go over instructions for using a tax map, let's talk about what a tax map is. So in each county, by law, there is a board of tax assessors. They're charged with accounting for and providing valuations for each parcel of land in the county. Valuations for the tax bill. That's the sole reason for it. Many in the public, though, including fields related to surveying, such as realtors and engineers, geologists, they have the false impression that the tax maps are accurate when it comes to boundary location. In other words, they believe that the property lines on the tax map are correct. They're controlling, they're authoritative. And this is not right. We'll study that more. Computer managed property data such as is now available is routinely available to the private sector. The tax map boundaries in a GIS format get dumped into a clearinghouse. People can grab them, put them into phone apps, Google Earth, LandGlide, hunting apps, four-wheeling apps, hiking apps, and they can see the property lines. And depending on how accurate the GPS fix is in their phone, they can get pretty close to the line mapped on the tax map. If the line is actually drawn geospatially correct, which is rare, then they can be actually all over the property line. But often it's not. And this phenomenon causes copious amounts of encroachments, boundary disputes, sales disputes, misunderstandings, dissatisfaction with surveyors. And, part of the saddest misconception of this is that sometimes people think that since it's done by the county, done by the, for the taxpayers and housed on a government website, that it is in the official county survey. I've heard that term used by people, by clients, many times, and it bears pointing out that before you can get to that data, you have to click through disclaimers and notices that says this is not accurate, this is not legal, use this at your own risk, and yet, of course, people don't pay attention to that. So we have all these technical standards for land surveying. You have all this stuff that you have to do to learn how to survey property, such as take this and some other classes. Here's the entire rule in the state of Georgia regulations on property, real property appraisals regarding tax maps. And I'll let you read it, but basically it just says that they have to keep one. Cadastral maps, which means maps that show property lines, or computerized geographic information systems are to be maintained by the appraisal staff. That's it. It does come down and say, in fairness, minimum mapping specifications shall include, and this just lists what has to be included. They want physical dimensions or acreage estimate for each parcel, but this is estimates and to show the parcel boundaries. And the whole reason for that is just in hopes that nobody is overtaxed and nobody slips through and doesn't get taxed. For years, large land areas would be mapped. You could look at it and realize that it was a couple hundred acres. The tax parcel had a deed for 12 acres. So there was a lot of land that somebody probably wasn't being taxed on. And through the years, as things have come up, most parcels are still taxed. However, just today, we found 3 parcels in a northwest Georgia county that individuals own that have not paid taxes on since the 1970s. They've not tried to do anything with it. We don't know if they even realize that they own it or not, but it's owned, and the assessor in that county has it lumped in with the Corps of Engineers as being part of Carter's Lake, and it's not. We've even confirmed that with the Corps of Engineers maps. So, again, there are no regulatory requirements for the accuracy of tax maps. This is not to devalue the utility or purpose of tax maps. In fact, they're fairly essential to our research. They're only a starting point. But this is where we go to learn who the adjacent properties are so that we can do our job of gathering the data and comparing the descriptions, going out and performing an accurate boundary retracement survey. I like to use this analogy. Tax maps are a lot like social media platforms. Imagine getting all of your data from Facebook. A lot of it's probably correct. Some of it's wild rumors. Some of it's just dead wrong. You have to try it to find out. So if the tax map says that John Doe owns the property next door, don't assume that, by gosh, John Doe owns the property next door. That's just a clue. That's just a starting point. We go get the deed reference, and we look at the deed, and we decide if John Doe is actually the adjoining owner or not, and we reflect our findings on our plats. So it doesn't mean, a lot of people confuse the plat standards that they just have to go in and grab the adjoiner's name and the tax parcel off of the tax assessor site, the Q Public map, and put that on their plat. That doesn't begin to satisfy the requirements of the board rules. So early tax maps were drawn by hand, as I alluded to, and sometimes they were very crude and incomplete. Tax records track sales data. This is where we get into it this is where we get into tax data and why it's useful to us. Their purpose is to track and establish values for tax bills, for the digest that the Board of Assessors votes and sends to the Department of Revenue and the Tax Commissioner every year. That's the sole purpose of this, not to keep people within their boundaries, not to show people how big their backyard is, or show people how big their house is. It's just to obtain a value for property tax purposes. So part of that process includes tracking sales. If they have a piece of property valued at $200,000 and it sold last year for $300,000, well, that's a clue they need to raise the value because the fair market value has been determined by arm's length transaction to be $300,000. They track that data for them, but they provide it to the public, which means us, and that includes usually the deed book and page. So there we're able to jump in to do our job under our rules. Another aspect that's really worth touching on is that tax map boundaries should be considered, by land surveyors at least, if not the whole public, as an indefinite boundary. Dictionary.com calls an indefinite boundary, quote, not clearly defined or determined, not precise or exact. That's a property line on a tax map. I also like to go back to legal basis and notice that 3 years ago in 2021, there was a court case in Chatham County, Rockingham versus Rockingham. And part of this came across as a quiet title action, and part of the defense was, I've got this tax parcel, this is what I own. That's the gist of it. You can pull it up and read it for yourself. This is a direct quote from the court's ruling. But even resort to the PIN map of unknown origin and accuracy, being itself hearsay evidence, does not provide affirmative evidence as to the property location on the ground. Even if provided the lot description along with a GPS and a road map, one would have no method or reference to locate an exact parcel on the ground. This is what the Superior Court in Chatham County, Georgia has put on the record, and that's very good counsel to remember. Now, next thing, deed records. So deed and plat records are physically kept in the records room. In Georgia, the records room is found in the Clerk of Superior Court, which is an elected constitutional officer in each county that's charged with keeping track of court records. They're also charged with keeping track of real estate records. Other states put them in other offices. For example, in Tennessee and North Carolina, they're in the Register of Deeds office, and that's an elected official. In Alabama, the probate judge keeps the deed and plat records. In Florida, the clerk of the circuit court and comptroller is the office that holds the deed records. So some government offices like this keep their deed and plat records available online. Some allow private services to come in and scan them and host them online for a fee, which is very common in Tennessee, for example. But one thing that's important to know when you're using online records is the dates of the effective data. Whether if it's, let's talk about counties in Georgia. So there's a law that says all counties have to submit their recorded deeds, plats, liens, real estate records to the Georgia Superior Court Clerks Cooperative Authority, GSCCCA. So the GSCCCA hosts all the records for all 159 counties that have been uploaded and transmitted properly to the GSCCCA. To search these records, you need a membership or a subscription, and then you pay per image. If you print or copy an image, it's 50 cents per image. Well, if it's plat, if it's a 3-page deed and you get all 3 pages, it's $1.50. But most of the counties have not gone back to the very beginning of their county. I know of only one, there may be others, but Gwinnett County is fully scanned and fully searchable back to 1832. Now, the good through data is usually, or the good through date is usually when the indexes are up to date. In other words, the indexes, which we'll talk about in a minute, are how we find deeds and plats. In a lot of counties, they have scanned the images further back than their good through date. For example, their good through date may be 1995. So for the last 29 years, you can find transactions on GSCCCA. They may have gone ahead and scanned and transmitted deeds and plats back to 1970. But unless you know the book and page, you can't find them because their data, the grantor, the grantee, the land lot, the GMD, the date, has not been filed into the GSCCCA index. The good through date means that you can search by name, some cases land lot, etc. So deed and plat indexes, deeds are indexed by both parties, the grantor or grantee. and grantee. The grantors are also known as the direct books. Some counties, the older books, instead of saying grantor, will say direct, or index to direct, or direct parties. And the other side, the grantee, are called the reverse or indirect books. So when you're online in a searchable index, you can search by grantor or by grantee, usually by name or entity, corporation, government name, etc. So historically, deeds were recorded into a book. Some counties started with A, some started with 1. They were free to do however, so you have lots of different types of lettering and numbering conventions in Georgia. When book 1 was full, they bought a new book, started putting deeds in the book 2. So physical books are still required to be kept, so recordings are still usually indexed by book and page, even if it's all housed online, because the clerks print and keep a physical copy available for the public to come in and view. A lot of counties, especially outside of Georgia, just have one massive virtual book for each year, like book 2023, page 14307. Yeah, there's not a 14,000 page book, it's just a virtual indexing system. And some counties will call that image 14307 or record 14307, not page. So the way this is done varies by county, and the books themselves vary by manufacturer and the county's individual preferences. So let's talk about how deeds and plats were indexed early on. So imagine going back before typewriters were very widespread. So each clerk kept a docket where everything that was recorded, regardless of what it was filed as it came in, irregardless of name, land lot, or whatever. You know, a deed from John Doe to Susie Clinton would just be put in the next line after the last person had brought something in. All this was handwritten, and so the filing docket would be organized chronologically, and then the deed or the mortgage or the lien would be transcribed by hand by the clerk or their staff into the book. So what I'm talking about is like copying somebody's homework. They would bring in a deed, and then the clerk or their staff would sit there and copy down the contents one letter at a time into the official deed book. So the handwritten deed records are not the image that you see in the courthouse. It's what a clerk or staff wrote down. So being human, sometimes the deed that was brought in wasn't that legible. So the scribe, as that person is known as, or as the scrivener, had to do the best they could, and so they might have got some things wrote down wrong. Sometimes they didn't write the cleanest handwriting, and it's impossible to understand exactly what it was. I've literally saw words that you could argue meant 3 different words. Obviously they were just one, but sometimes that can make a lot of difference. So you have to be mindful about these things when you're looking at the very old handwritten deeds. Now, around 100 years ago, typewriters became more available, and instead of handwriting the copies into the deed books, they fed the deed book pages through a wide platform typewriter and typed them in one letter at a time. So that was better. They're a lot more legible, but they were still transcribing often handwritten deeds that they often couldn't totally understand. So then, once copy machines were available, the clerk's office would take a deed, they would copy it, they would enter it into the book. Usually they would copy it onto the pages themselves. They would take the books apart, or that's how they would come. They would just take them all apart and feed the pages through the copiers and get make a copy of the actual deed onto the deed book page that you can see now, or the image thereof. So the original deeds are always returned to the party who submitted them. Plats were very similar. In the early days, they didn't have copying machines or blueprint machines. So the scribes in the courthouse would hand copy the plats as best they could. So if you see, a very old plat recorded usually in a deed book, because a lot of counties didn't have plat books until sometime in the mid to late 1900s. If the lines look crooked, if the calls are not legible, don't shake your head and say, wow, he put his bearings and distances in cursive and that's so sloppy. Now, you don't know what the scribe was looking at. It might have been a beautiful plat with beautiful lettering, but it got copied by hand by someone who wasn't as talented. So similarly, as copiers came along, the actual plats would be copied. Or for the longest, you had to take extra copies, and they would just record one of your copies right into the plat book. They would glue it in usually. This is what it looks like inside a records room. So this just happens to be the Gilmer County Clerk of Superior Court record room. And in front of us, we have some grantee books. We'll look at these more. Back here in the back, you can see the deed records. You can see some more deed records, and these are workspaces where people can sit. Most people do so much online now that there's not that many people in the records room anymore. But right here is something to point out, that they have a computer terminal. So most all these courthouses have a computer terminal where they often have images and indexes and things available in the courthouse, in the deed room, that's not available online, either on their county websites or on GSCCA. So these over here are the grantee books. And let's see, this is like the filing docket and general index to deeds and realty mortgages. This is from 1983 to 1984, letters A through Z. This will vary from county to county and within individual counties. So, here this is a wider span. I think it's 56 to 77, but they've got L through Z in one book and A through K in another book. And then, in the mid-'80s, they started printing them off, usually on a dot matrix printer. They can be kind of hard to read, but if you're looking for an example like Brown is the example that I've used, let's flip over. Let's look at, these are the grantor indexes, and you can see it's the same thing. You see the books are coming apart. They're not used that much. Days and weeks and months probably go by when these books are never touched by a human. But these are the books, and like for example right here, this is book number 1. Grantors from deed book 1 through December of 1955. So everything in the county on the grantor side was recorded in this book. This is where you find it all the way up to 1955. So within the cover of these old books, there's this filing index or a key table. And this is how you would find it. For example, let's look at the next slide. I've zoomed in. So you see where I was looking right up here, BI, last names beginning BIA to BIG to BIL would be on page 17. BIM through BIN through BIR to BIZ would be filed on page 19. Now, Brown is my example, and so that is BRO, bro. That says page 33. So here, look at the bottom of the page. This is 33. I cut part of the page off. But on page 33, you'll find, this is from 1977. This is a grantor of Brown. Then you have Brookshire, because BRO also is the first 3 letters of Brookshire. So you'll have Brown, Brondy, all these different names that start with BRO are all on page 33. When they ran out of page 33, they turned the page and used the next blank one and called it 33A and then 33B. These are things that you have to know if you're looking. The best way to find out if you're being conclusive in your search is to make sure that the dates of recording correspond with the dates on the book. So if it's a 1974 to 1984 book and you turn what you think is page 33 and it starts in 77, well, you probably missed about 3 years somewhere and you need to keep looking. But here you'll see all this is handwritten, even in 1977 or 1978. And so they'd write in a land, lot, and district section, the book and page. This is the main goodie that we're looking for here. Although where you have one party that owns a lot of things, you may want to be looking over here in the land, lot, and district. So if you're looking for something in land, lot, 150 of the 7th district, then you know that this Waldo and Dorothy Brookshire is not the deed that you're looking for. You need to keep looking until you find something in that landlocked district. Less helpful are when things are filed and there's a reference to a GMD. But often in the GMDs, they'll list a road that it's on. Here they're listing the subdivision, lot M67 of Walnut Mountain, for example. So that's how you use an old index. Going back to the rule and the contents thereof, they list certificates of title. Now, a certificate of title is a rare bird nowadays. It was more common 40 or 50 years ago when the rule was written, but it's still applicable. Title certificate is when an attorney will go examine the title of a piece of property and write out a piece of paper on his letterhead and sign him or her and sign it. And it says, well, basically, we find that John Doe owns the 5 acres described in their vesting deed in Deed Book 48, page 255, being 6 acres in Land Lot 1 of the 5th District of Podunk County. They'll also examine for any encumbrances, liens, and easements and things, and say the property is subject to a loan to First National Bank and an easement to Podunk Valley Electric Membership Corporation or Georgia Power Company. So what we see now, the purpose of the title certificate was if you were thinking about selling your land, people would want to know if you had clear title. So you would preemptively hire an attorney to check your title to make sure that everything was good so that you didn't have any hiccups and so that you could fix them at your own time frame. So now what they do is, or what's more common, is a title commitment. So that's a commitment by an attorney to issue a title insurance policy on a piece of property. The title commitment will list the vesting description and all those other things that I've said. So what happens is after the closing or at the closing, the attorney that's committed to issuing a title policy will then issue the title policy, and it'll have the same exceptions to coverage as the title commitment has, so that there are no surprises. So what that would mean if an easement to Amicalola Electric is an exception in the title commitment, that means that they're ensuring that whoever uses that, the buyer, the lender, they have free, clear fee title to the property, except for blah, blah, blah. All the encumbrances and things that basically cloud title, but you voluntarily cloud your title when you execute a mortgage or an easement, etc. So all of this data can be invaluable to the land surveyor. Title commitment is and title policy is part of almost every real estate transaction in the whole country. So while it may not always be available, sometimes they're right down to the wire, like the surveys, and they don't have a title commitment available until after the survey. Some attorneys don't even want to search the title until they get the survey, which is kind of difficult on the surveyor. And I'll also point out that in an ALTA NSPS land title survey, the surveyor is required to be furnished with the title commitment, review it, plot the exceptions when they're plottable, and comment on each one as to if or how they affect subject property. So it's important in most, but not every instance. If there's any question or any uncertainty, ask for the title commitment, because one is being prepared. It's not a chore or a burden or an additional expense for the client if there's a transaction involved. Now, if someone just says, I want to survey my property, you might ask them for if they have their title insurance policy that they could share with you. Most people have no idea where that is. But if there's a sale or a finance coming up where they're having title work done and they're going to be issuing a title insurance policy, then that's where you can say, okay, can I get it? Can I have access to that? It's the best product for the client and the public when the surveyor and the title work get to share information with each other. Centerline and right-of-way data. So we'll talk about this more. Part of the this week's assignment is to watch a very detailed video or two by the Georgia DOT. I'll just say that when you're next to a street or a road or a highway, you have an obligation to try to find the data for that. You may find it easily referenced on a prior survey. You may be able to, it may be provided to you in a title commitment. That's a great source for adjacent right-of-way data. But realize that the road boundary is property line just the same as the one between two pins on the back of the property. It's just as important. If you get it wrong, mistakes and problems will follow. So in the case of Georgia DOT, through some processes, you can get their centerline or right-of-way data. Counties and cities are a lot less organized and a lot less forthcoming, and in a lot of cases they don't even have right-of-way plans or right-of-way data. We'll get into that in the analysis and how to look at claimed right-of-ways and prescriptive right-of-ways. But if there's any question, you at least have an obligation to try to find it. Make a call to the road department, ask them if they have it. They might surprise you. I know a few very rural counties that you would think would not be organized at all, that within an hour or two can email you a right-of-way deed. Now, it's usually not right-of-way survey data. It's just going to say 30 feet from the center line of the road, 25 feet from the center line of the road, that sort of thing. So the center line of the road defines the right-of-way boundary in most rural instances, but at least you know that it's not 40 feet from the center line or 10 feet from the center line, and help you to get it right. Another type of center line and right-of-way data that you could talk for hours about pertains to railroads. I'll hit the basics. So when railroads acquired property to build a railroad on, sort of like a blanket easement, they didn't know exactly where it was going most of the time. They were just trying to build a railroad from Athens to Augusta, for example. And so they would get their surveyors and they would plot out courses and they go talk to people. And if somebody said, yeah, I'll give you a right of way, well, they get them to sign it right then. I've seen instances to where they relinquished it later because they built the railroad over somebody else's property, probably because they couldn't deal with another owner, couldn't acquire the property, so they had to move the railroad location. Or perhaps the grade got too steep, or the bridge was going to be too high or too long. So they would acquire right-of-way while they were designing it. So the railroads were highly favored by the U.S. government. They had lots of pluses because the government understood the value to our growing, burgeoning young country if we had railroads. So they made it enticing. They reimbursed railroads per mile for building railroads. So they were basically getting paid. So if dollars were a lot different. Let's just say they were paying $500 a mile to build a railroad. If they build it for $600 a mile, well, they didn't get all of their investment back, but they got a railroad to operate and make money off of. Sometimes they could, build a railroad for $400 a mile and make $100 off the government. So anyway, they were chartered. The state or the federal government, depending on the railroad charter, would issue a charter, and that says how the railroad could go about getting property. Some instances they can actually condemn through eminent domain and get land for the railroad. In other cases, like I said, it was very conducive, very pro-railroad. They would get a blanket deed basically for land lot 44 or a certain quarter section or a whole section in the western states. The intent was just wide enough to build a railroad. And in the later years, most of the railroads in Georgia, they'll say 50 feet or 66 feet or 33 feet or 75 feet or whatever it is from the center of the railroad. So where the railroad winds up getting built, that defines the right-of-way boundary. Now, this went on, and the railroads would then start trying to claim that they had the whole section. They built towns in some cases on what they considered to be railroad land, thanks to these charters. Sometimes thanks to these, almost blanket deeds that people gave them. And, private property owners couldn't compete. The railroads had the railroad. If you ever noticed, towns sprang up all through the country along the railroad. Everywhere that they had to stop and take on coal or water, there'd be a depot where people could get on and off, or where they could load and unload goods. So the railroad was the highway. It was the lifeline. And so people realized, around the turn of the last century, that the railroads had too much power and that the government had given them, way too much favor. And so in 1913, Congress passed the Railroad Valuation Act of 1913. This law required all railroads to have all of their railroads surveyed and mapped and submit by a staggering series of years to Congress what they considered to be their railroad property. And in order to help convince the railroads not to claim too much, the federal government started taxing them on the value of their railroads. So they didn't want to own any more land than they really needed. So that kind of curtailed their claims. But this kind of put it in stone that this is what they own. They can't come back and say that it's somewhere else. It's put on official record. They're now housed in they were initially submitted to the Interstate Commerce Commission. They're now housed in the Library of Congress and or the Federal Archives. They're hard to find through the Federal Archives, so we usually go to the railroads themselves. But these valuation maps are very helpful to the surveyor because they show the property owners along the railroad at the time of the survey or sometimes at the time of the acquisition. So if you're trying to find a railroad right-of-way deed from 1870 and it says John Quincy Adams as an adjacent owner, well, you don't have to run the title, the chain of title of the property you're surveying all the way back to 1870. You can just go look for John Quincy Adams in the A grantor book to see what he granted. And so it's important to know that, that all of the railroads, with very, very rare exception and recent twists and additions, were built more than 50 years ago, and that's as far back as title searches have to go. So you have to dig deeper, and you really have a due diligence to obtain the VAL map or the valuation maps that the railroads had to submit and maintain. They're nicknamed in the surveying industry as VAL maps. So VAL maps, in some counties, they went in a few years ago and recorded all the VAL maps in the whole county in the plat records, but they're not indexed by Landlord or GMB and searchable. They're just there if you know where to look for them. Otherwise, you have to contact the railroad, which can be tedious, and one in particular charges $500 per VAL map. So you got to factor that into your quote when you're surveying a piece of property next to a railroad. So let's put the process together and we'll wrap this up. So number one, the subject property, you need to find it on a tax map. A good practice is to print that portion of the map that shows the property and the adjacent parcels. If it's a big property with a whole lot of adjoiners, it may take multiple copies, but this is what is standard practice, to take the tax map and start writing the info down. You can either write it by hand, you can pull it on a PDF and edit it, make it real pretty on the PDF editor. You can even drag it into a CAD file. It doesn't really matter. The process is the same. You need the names of the owners and the deed references. And the deed references will be from the tax card or the record for each tax parcel. And like I said, that's a starting point. It may not be the only deed that vests title to that property. I'll give you an example where you do that process, you pull the deed. Later in the analysis, when we're looking, you'll find where, well, this deed for John Doe doesn't actually join us at all. A little bit more looking, this is an exact situation I had not long ago. That deed was for 5 acres. Little clue, you go back to the tax record, they're being taxed for 13 acres. So you run grantee on that person, find where they bought 8 acres from somebody else a couple of years earlier or later, and that's the description that abuts your property. So anyway, we start by compiling all the information from the tax map, the names of the adjacent property owners. Beginning with the subject property, you pull the latest deed for each adjacent property, write it down, like I said, in step 1, and then you start retrieving these from the clerk's office or GSCCA or from the clerk's web page. Look carefully for any references to recorded plats or other recorded deeds and retrieve those as well, or at least view them to see if they are applicable. Number 3, when you have a title commitment, incorporate that into your research. It can really help shortcut and fill in a lot of blanks. You're taking advantage of the horsepower of a professional title examiner, and so you're dumb if you don't take advantage of that when it's available, especially when you need it. They also list the easements and encumbrances that they have found that they feel like affect the property. So these are things that we're supposed to show on plats. Take advantage of this. Number 4, all the adjacent road right-of-ways should be researched, other centerline and right-of-way data, power company maps, etc. And again, a lot of these can be found in the title commitments. And lastly, other records or plats besides the recorded ones should be searched for when available. And the sources will vary, as we've said, but they may often explain a lot of things. I'll give you one quick example and then we'll close this lecture. Part of the analysis is going to be evaluating monuments as to whether they should be controlling or should be held or not. If the plat that you're surveying by and the description call for an axle, and you go to that location and there's no axle to be found. In fact, the ground looks like it's been graded and disturbed and there's a rebar there. And the measurement's not exactly right, but here's a rebar. Well, part of testing that rebar is to try to figure out where it came from. If you don't know, we evaluate it a different way. If the neighbor or the tax assessor or Georgia Land Surveying Archives has a plat on record, and I've had this example happen, where it says iron pin set at former location of axle. So maybe they knew the axle was going to be disturbed or tore out by grading that was permissive or something, and the surveyor replaced that position with the rebar. The rebar then becomes the highest evidence of where that axle and thus the property corner is supposed to be. Otherwise, it's just a piece of metal stuck in the ground, and you have to evaluate it differently. But that's one way to where these unrecorded plats can be very helpful in the analysis and the resolution of boundaries. That concludes the lecture on the introduction to property research. Next, we'll take up how to analyze it.